Okay, and I see our next guest is here, so we will just move forward. North Dakota is no stranger to the services provided by the Public Health Law Center. The PHLC provides many communities and policy review and assistance with policy development. I'm a huge fan of our next presenter, who does a fantastic job of effectively communicating tobacco control issues relating to the industry and government regulatory efforts. Natalie Hemmerich is a senior staff attorney at the Public Health Law Center working on commercial tobacco regulation. She specializes in federal regulation of commercial tobacco, tribal tobacco work, and is the chair of the equity committee at the center. Welcome, Natalie.
Hi, Neil. Hi, North Dakota. Thank you so much for having me. I appreciate being here very much. And thank you for that nice intro, Neil. You always make me a little nervous because it feels like high expectations to live up to. But hopefully, I will provide you with worthwhile information. Okay, I tried to share my screen. And now I don't know where everything went. Can you see my screen?
No.
No. Okay. I can no longer see Teams at all. So
okay, you're still on, so give us just a moment. We're working with our tech person.
I'm not seeing it either, so if you'd like to stop sharing, I can go ahead and share from here, and I'll just follow your cue.
Yeah, I don't see any controls to even stop sharing. That's my problem. It's complicated. Wait. Oh.
I saw it.
I'll see if I can override you here.
Oh.
I think we should be good. I'll just follow your cues.
Okay, so you're going to go ahead and do it on your screen. Okay, go ahead and go to the next slide then. Sorry, my computer has like very little RAM, so I turned off my camera. Hopefully that will help. I also want to preface that I've had COVID for the last like 3 weeks, so if I'm coughing a little bit, I'm very sorry, but I am on the up and up. So Neil mentioned that you know about Public Health Law Center, but we kind of have a spiel we do before any of our presentations. So this is the Public Health Law Center. We're located in St. Paul, Minnesota, at the Mitchell-Hamlin School of Law, and this is our wintry scape of the school. You can go to the next slide. And we like to talk a little bit about what we do and how we do it. And so this is our slide that talks about equity and how we approach equity. So all the work that we do is done in consideration of advancing equity. And what this means is that we're focused on partnering with communities and organizations to use the power of the law in a way that addresses the social determinants of health and meets the specific needs of all communities, especially those who unfairly bear a greater burden of public health and other societal harms. And another part of our equity work is to mention that when we're talking about tobacco, and when I talk about tobacco, I'm talking about commercial tobacco and not about sacred or traditional tobacco that's used by Indigenous communities in their ceremonies, practices, and religious beliefs. Next slide. I keep losing. Okay, there we go. Sorry. This is sort of a short overview of what we do and what we don't do. Although we're lawyers, we don't provide direct representation and we don't lobby, but we do do trainings like this or webinars on our website. Often we do legal research, we help draft ordinances and statutes, and so we provide a lot of educational materials all over the country and in North Dakota for communities hoping to enact commercial tobacco policies. Next slide. So those are my spiel slides, and this is more of what I'm going to talk to you about today. So folks asked me to talk about the FDA and what's going on with the FDA because a lot of not as much recently, but at the end of last year, a lot of action was happening and a lot of discussion was happening about pre-market review and what is going on with the FDA. And I'm going to delve just a tiny bit into synthetic nicotine because we also have been getting a lot of questions about that. Next slide. So just to give you kind of a background so that I can more clearly talk about the issue of pre-market review. Next slide. I want to talk a little bit about, give you just a little refresher background on the FDA and their pre-market review authority. So essentially, after the Tobacco Control Act was passed, it established that no new tobacco product could come onto the market or be sold in the United States without first receiving authorization from the FDA. So that means that all e-cigarettes, which were pretty much across the board not sold until after February 15, 2007, must go through the pre-market review process in order to be commercially marketed in the U.S. And that February 15, 2007 date is the date that the Tobacco Control Act establishes. If you were on the market before that, you could do one process, and if you're on the market after that, you have to do this new tobacco products process. So the letter of the law is that all e-cigarettes require that marketing authorization from the FDA in order to be sold. Next slide. So that means the FDA works as a gatekeeper. Products don't come onto the market unless they show they can meet the Tobacco Control Act's public health standard. And that means that their marketing is appropriate for the protection of public health. And next slide. You might be wondering, what does that mean? And this is the standard from the Tobacco Control Act that talks about what the public health standard is. This is the standard. So it's looking at the risks and benefits to the population as a whole, focusing on users and non-users. And in authorizing a tobacco product, the FDA has to consider whether the action would increase or decrease the likelihood of existing users of tobacco products who will stop using products, or increase or decrease likelihood of those who do not use tobacco products will start using tobacco products. Next slide, please. So after I say all that to you, you're probably like, well, I know there's lots of e-cigarettes on the market. What are you talking about? How is that possible? And essentially, this is a picture of the gate being open. I previously showed you a picture of a gate being nicely locked, and this is open to sort of indicate that the FDA is not served as an effective gatekeeper at all. Next slide, please. So I want to tell you more about that, but I'm going to get a little bit into the background first of how we got here and what that means in the grander scheme of data. Next slide, please. So this is data, this is national data from the NYTS, the National Youth Tobacco Survey, over the last several years, and it doesn't have the very latest data on that. I admit that. The last year that it reports is 2019, but you can see that, and this is youth use, you can see that cigarettes, it's a pretty good story, falling consistently over time. Cigars is a little more mediocre, but still on a good trajectory. And then obviously e-cigarettes, not at all. It's going much higher, and that impacts any tobacco product, which is on the far left. So next slide, please. And this is the latest NYTS data from 2021, which was collected during the pandemic. So it has the caveat that there was disruption of data collection, but you know, that indicates that progress has been made, and that e-cigarette use is declining. But I plan to talk about how that's not really related to the FDA and their action. And so, but I do want to admit that this is like the latest data, but at the same time, the youth use rates are still alarmingly high. It's not as if we've won any sort of battle. And also considering that we don't know exactly how the pandemic impacts this and what will change when things, go back to some sort of normalcy, we will see. If you could go to the previous slide, I'm sorry, I want to go back to that. Thank you. And I should have added this slide after this one, but I circled on the very far right, I circled that little orange circle there. That is the time period when the FDA actually asserted its authority over e-cigarettes. And so what I wanted to talk about in this slide as well is that the FDA in 2016 asserted their authority over e-cigarettes. And at that time, they were able to actually remove all e-cigarette products from the market, but they chose not to, and they chose to give a grace period. I'm going to talk about that in a minute, but I just want to indicate that this orange circle here is indicating that time when the FDA asserted their authority and chose to not immediately remove e-cigarettes or not immediately take strong action against e-cigarettes. And you can see how the trajectory increased after that. Okay, can you go forward 2 slides? Please. Okay, so, and this is what I was indicating just now when I was talking about this. So the top, this is a little confusing, but I'm going to walk you through it. I don't want it to feel overwhelming. But the top line is what the FDA proposed when they initially asserted their authority over e-cigarettes and other newly deemed products. So this is any product that isn't cigarette, smokeless, or roll your own tobacco. And this is actually the timeline specifically for e-cigarettes because they did treat those a little bit differently. But they proposed that they would allow e-cigarettes to remain on the market for 2 years, and then after 2 years, they would need to put in applications and receive authorization to remain on the market. So if they had stuck with that plan, all e-cigarettes on the market as of August 8th, 2019, would have had authorization from the FDA, and they would have been fully executing their pre-market review authority. Instead, in 2017, they announced that they're going to have a different regulatory plan, and this second line shows you what their plan had been. So we still today would not have been at the date that e-cigarette companies would have even had to put in applications to receive authorization from the FDA, which is problematic. Next slide, please. And the timeline that we're on now is actually a timeline that the court imposed upon the FDA after public health and other health groups sued the FDA, saying that they were not doing their duty as it regards to pre-market review, and the court agreed that they were unreasonably delaying action. And so the new deadlines were that by September 9th, 2020, all manufacturers should have their applications into the FDA, and they could remain on the market for a year while the FDA made a decision, and the FDA was supposed to make those decisions by September 9th, 2021. And if you've been following this at all, you're probably curious how that's possible, because we are currently 5 months past that deadline, and there are, and I'm going to get to this a little bit later, but there are about 850,000 products that have yet to receive any decision from the FDA. And we get a lot of questions about how that can possibly be. And all that we can say is that these products are, by the letter of the law, being illegally marketed and sold, but the FDA is not actually enforcing that. And so if the agency that's intended to enforce that isn't enforcing it, then what's happening is what's happening, that all these products are remaining on the market, even when they, according to the court order, should not be on the market because they don't have that authorization from the FDA to be on the market. And I will tell a little bit about the updates in that court case in a minute. Next slide, please. We get some questions, next slide as well, about the process. And so this is adapted from the FDA's website, and I just thought it would be helpful to see a little bit about what the process was for pre-market review applications and for manufacturers. And so what happens is that on that September 9th date, they were intended to put in all their applications, and then it goes through this process with the FDA. So the FDA can either accept them or refuse to accept them, which has happened. And then there's a process called filing. And so the FDA at that time can decide whether to file them or refuse to file them. And if they don't get filed, then they don't get reviewed. And after the ones that have been filed, they go through review. And then it's not until nearly the end that you see that the action happens. And so you'll see either authorizations or marketing denial orders at the very end of the process. And after that is like litigation or the ability to remain on the market or to be able to sell your product. Next slide, please. And then one more, please. So starting in, I probably should have put dates since now we're a year out from when this started, but starting in January to February of 2021 is when we first saw warning letters to companies going out for products that did not have applications. So they missed the deadline of September 9th, 2020. And then in February, we started to see updates on the FDA's website about their progress on processing applications. And so this was the figures from that time, so from February. So they received 6,800 product applications and some exemption requests. And then for pre-market review, they received 4.8 million product applications from 230 companies. Next slide, please. And then March through August, we saw more warning letters. And then starting on August 26th is when we first saw the marketing denial orders. And you probably saw, if you were on any of the email lists from the FDA, you probably saw a lot of communications about those. As far as we know, that the warning letters were only warning letters. I have not seen. Sorry, I don't know if I'm missing something in the chat that's important. So they're not fines. Warning letters are just warning letters, and they're not penalties, and they're not seizure of products. And we haven't seen the FDA take any additional steps besides warning letters at this point. And we've seen that the warning letters have gone out to both those products that didn't put in applications and now products that have been issued marketing denial orders, but they are still marketing their products. Next slide, please. And this is the latest numbers that I have about what happened with all of those applications that I indicated. So 200,000 products got refused to accept. And then at least 4.5 million products got refused to file. And then 946,000 products got negative marketing orders. So what we know from the original amount of products is that there's about 850,000 products that have yet to receive either a denial or an authorization. Next slide, please. And that's a really big figure. So people usually have a question about that. And the 4.5 million refused to file. Next slide, please. And most of those, I think, come from one company, JD Nova. I don't know why I came up with JM Cat, but JD Nova was one company that put in hundreds of thousands of applications, and they got a ton of denials or a ton of refused to files. And so that was where that really large number came from. But highlighted on the right is all of their applications in the database. Okay, next slide, please. You're probably wondering about, well, have there been any authorizations? And my answer is yes, there have been authorizations. So besides the denials that they've given, in October of 2021, the FDA issued a handful of authorizations. And these orders are for a Vuse device, the Vuse Solo, and 2 of the 4.8 nicotine strength tobacco flavored cartridges that go with it. And also for the Verve products that are like dissolvable discs that Philip Morris put an application for. And next slide, please. Although the FDA indicated that that when they were processing applications, they would do a strategic form of processing, applications that would focus on products that had the largest market share first. What we know about the first authorizations from the FDA is that clearly hasn't happened. So Verve, which I mentioned is this disc thing, is a product that Philip Morris put an application for. And in trade magazines, Philip Morris has indicated that it no longer markets this product, and it also doesn't have any intention to market this product, and that the reasoning for putting in that application in the first place is some sort of vague answer about the technology, which doesn't really make sense to me, but it's bizarre that this is one of the first companies to have received authorization from the FDA when you consider that they indicated that they would be doing this based on market share. So a product that's not even being marketed and has no intention of being marketed has been authorized. Next slide, please. And the other product is that Vuse Solo product that is not at all the most popular Vuse product that exists. The most popular Vuse product is the Vuse Alto, which is their Juul-like product. And that also doesn't make sense from a market share standpoint. So what we know is that really popular brands with youth like Juul have not received any decision making about their applications. Next slide, please. So there's a few things to take away from the authorizations that have happened. The good is that the FDA has not approved or authorized any flavors. I should say authorized, not approved, and I'll talk about that in a minute. So my apologies for that. So they haven't authorized any flavors, which is a good thing, and consistent with the limited sort of action they took, restricting the sale of some flavors and cartridge-based products back in 2019. But the concerning things about the decisions that we can see and discuss is that the nicotine strength in the Vuse Alto product specifically is extremely high. It's much higher. It's double the limit, I'm pretty sure. Double what the limit is in Canada, the UK, and the EU, I'm nearly certain. And they said while they denied some of the flavor applications, they are not making a decision yet about menthol, which is concerning because we know menthol is a very concerning additive and a uniquely concerning additive when it comes to nicotine and how that impacts addiction and dependence. And then the last thing is that the FDA caused a lot of confusion about this issue of authorization versus approval, which is what kind of my code name for talking about the fact that, next slide please, that the FDA, when they were making their announcements, they made several announcements that indicated that, you know, the data demonstrates that tobacco flavored products could benefit addicted adult smokers, and they were causing a lot of confusion about whether these are now approved by the FDA. And although, next slide. Next slide. Oh yeah, okay, you're there, sorry. Although the FDA later on in the announcement says that the FDA does not mean that these products are FDA approved, their language is certainly confusing about what they mean when they're talking about how these can benefit smokers. And a lot of the media portrayed this as new cessation products, which is inaccurate. And the distinction between approval and authorization that I'm getting to is that on the drug side of things, where cessation products are approved by the FDA, that process is that for drugs is that things should be safe and effective and, you know, proven to benefit health. And so NRT cessation products are that. But e-cigarettes are not that. They receive authorization from the FDA, and that's an important distinction because the FDA can never say that any addictive nicotine product is, you know, beneficial for health or that the benefits outweigh the risk in any way. If you could go back to slide 27, that would be great. Down here on the bottom, I put a screenshot of a blog post that I wrote about pre-market review process. So that is another good place to kind of read through some of this and understand what's going on. And I talk a little bit more about that approval versus authorization and the impact of that for local ordinances or for state statutes. Okay, if you could go to slide 30. So I talk to you about this. This is that court ordered timeline, and you know that there's lots of products that are on the market and that shouldn't be on the market. And for a while, we weren't really sure what was going to happen, and you know because the court case had been administratively closed, and we weren't really sure what was going to happen if the plaintiffs would have to start a new litigation or what they needed to do to address that the FDA is not executing executing the court order as they should be. But the latest update in this case is that the plaintiffs did motion to modify the order and to get status updates from the FDA and to, you know, make the court aware that the FDA was not abiding by the court orders. And the FDA responded in December, and they said that they, in opposition, they didn't agree, and they thought that they asserted that they were making considerable headway, and that they were defending their marketing denial orders, and that they were doing a good enough job, and that the court should go ahead and keep the case closed and not have oversight over it. And what we don't know yet is how the court is going to decide and what they're going to do with that motion from the plaintiffs to have the court be more involved and force the FDA to be more accountable for not following through with the court order. Next slide, please. The last thing I want to talk about for pre-market review is the existing litigation, which I just mentioned. Next slide, please. As far as I know, which is kind of hard to track, to be honest, but as far as we know, there's 48 lawsuits challenging marketing denial orders, refuse to accept letters, refuse to file letters. And this is not a full list of them because all 48 wouldn't fit on my screen, but it's an example list of some of the court cases that exist. And then I sort of color-coded the ones that are on here to give more information. So the yellow one is one that the FDA decided to go ahead and rescind the motion to or the marketing denial order, and they are essentially reconsidering the application. And then the green ones indicate where the plaintiffs, the manufacturers, asked for the court's authorization to keep manufacturing their products while the court case is going on, and the court said no. And then the pinkish colored ones are indications where the plaintiffs asked for the same thing, that they could keep marketing their products while the court case is going on, and the court said yes, they could. So that's and there's more of those. There's 25 total of those than I have pictured here. So that's sort of the current status, but we haven't gotten to like really any of the merits of the litigation. And if you ask me how I think it's going, or how I think it should go, or how I think it will go, I don't know if there's a difference necessarily between those. It's very clear that the FDA has authority to make these decisions, and there is a principle within the law that sort of gives deference to an agency as it's executing its duties. And so I think that ultimately all of these orders should be held up in court. I think that's how it should work. I will see how it does actually work, but that there's a lot of reason to think that that is what should and would happen. Next slide, please. I just want to briefly talk a little bit about synthetic nicotine because that is sort of a related topic. And the reason that it's a related topic is that as the FDA has started doing the pre-market review, we've seen many more products pop up that claim to use synthetic nicotine. And the reasoning is that, next slide, please. The reasoning behind that is like threefold, I would say. One is that it's become cheaper to do. Industry documents from 20, 30 years ago indicated that it was super expensive and it wasn't the best way to approach getting nicotine. The methods now also provide more bioavailability of the nicotine than previously was able to be created in the lab. And the third reason is policy and why I'm mentioning. So like as pre-market review has been happening, it's incentivized trying to not be within the FDA's tobacco authority and to not be subject to things like pre-market review or to have your flavored applications denied. And so an example, the most kind of famous example of that is on the screen now. It's Puff Bar. And the latest NYTS data indicates that this is the most popular brand that current e-cigarette youth users use as well, which is concerning that they are using synthetic nicotine and not being subject to pre-market review or any of the other FDA regulations that exist or will exist. Next slide, please. And here's some more examples of products. And the sort of important thing about this is that their products is not just e-cigarettes, it's some other products as well, like gum and these pouches, and we've seen like sprays and things like that. Next slide, please. So as I said, like the current situation is that the FDA, without being comprehensively regulating nicotine, they're incentivizing using synthetic nicotine, so you're not subject to the regulations that the FDA is enacting for tobacco products. So, and this is a little complicated, but the FDA has their tobacco authority, and that's the Center for Tobacco Products that executes their tobacco authority. And the Center for Tobacco Products can only regulate things that are made or derived from tobacco. That's what the statute says specifically. But that's not the end of the FDA's authority. They also have drug and delivery device authority. And so there's I argue, and I have colleagues that argue, that there's no reason that the FDA cannot address these synthetic nicotine products through their drug authority, because these products nicotine clearly affects the structure and function of the body. And like, for example, these products often talk about how like clean and there's no flavor, there's no scent, it's no impurities from tobacco. And, you know, if that's true, then why would you be adding nicotine to a product other than to produce some sort of bodily function or bodily change in the person, you know, changing the brain and the impact that nicotine has on the brain. The drug authority works a little differently than the tobacco authority, so it's a little bit more complicated, but there's no reason why the FDA's drug authority, their center, CDER, couldn't start sending warning letters to these manufacturers and, you know, de-incentivizing using synthetic nicotine. But the good news, although the FDA is not doing a great job, the good news is that tribes and states and localities can and do regulate synthetic nicotine. And so when you're asking yourself about whether your state law or your local law addresses synthetic nicotine, it's typical to look at the definitions. So I gave an example of our model definition for e-cigarettes. So to capture synthetic e-cigarettes, this is an example of a definition that would capture synthetic e-cigarettes. Next slide, please. And this is to capture these other products that are not e-cigarettes but still use synthetic nicotine. This is our not complete model definition, just the first part to show you that this is another definition that would capture these other synthetic nicotine products. Next slide, please. So that's pretty much everything I had to present to you. So the main takeaways that I was trying to get across is that there's a lot of action around pre-market review. It is underway, although it seemed like things were going to start happening in October, and now it's February and we still haven't had any other significant decision making from the FDA. So I'm not really sure when we can expect that to pick up again. But as I mentioned, all of the products by sort of the letter of the law and legally speaking should not be on the market unless they have authorization. So really just Verve and Vuse Solo are the only products that should be in stores that are the newly deemed products. So the e-cigarettes, all other e-cigarettes should not be on the market. And because the FDA hasn't made these decisions, the biggest, manufacturers that we know about, like Juul, are still in limbo, and we don't know when those decisions will happen or what those decisions will be. There is the good part that they've started denying flavored e-cigarettes. That's a good thing. I wasn't sure they were going to do that, but they haven't addressed whether they're actually going to deny menthol e-cigarettes. And, the actions that they're taking, they keep claiming, and even in court claiming, that they're doing a really great job, but it's obvious that, not really. And then I talked a little bit about the authorization, confusion between approval and authorization, and how that's causing confusion for a lot of localities. And we can talk more about that if you have questions about that. And then finally, synthetic nicotine, I mentioned that pre-market review is driving products to start trying to use synthetic nicotine, and the FDA isn't comprehensively addressing it like it should by using its drug authority as well. And that's undermining pre-market review, and it's undermining other policy initiatives that the FDA is or will be taking. And that's all I got.
Thank you, Natalie. That was fantastic. We did have a question that came in. If the FDA does ban menthol, should we expect an industry lawsuit trying to overturn the pre-market review process?
I guess I'm not sure exactly how those two are connected in your mind for this question. I don't know if the person that asked it wants to give more clarity, but if the FDA bans menthol, I think we should expect to see a lawsuit about that for sure. But I'm not sure how that will impact any litigation about pre-market review. Although I do think that if the FDA bans menthol, I'll be interested to see, because they've indicated that they're pausing on making a decision about menthol and e-cigarettes, and I would be very interested to see like what they're waiting for and whether it's whether it is the ban on menthol and cigarettes. But I'm not really sure what they're thinking there.
Okay, another one came in. Why would manufacturers be denied continuation of product production during a lawsuit while other manufacturers 25 plus be allowed to continue production? If you got the answer to that, I'd appreciate that.
On that slide, you can kind of see that it is divided up somewhat between the different circuits. So the Fifth Circuit is very consistently allowing products to stay on the market. And I think the 7th and 10th as well, but then the 6th and 11th is like granting the stay. And that's really just a court decision, and there's no really rhyme or reason. I mean, there's a legal standard, but because it's somewhat up to discretion of the judge, that, you know, it can be interpreted either way.
So you didn't have to worry about the bar being set too high because you did a fantastic job as normal. And one thing I love about Natalie is she allows me to say things that I don't usually hear said. My main concern is about the FDA and injury prevention for them, because I don't want them to hurt themselves patting themselves on the back for all of the great tobacco work they've done. I think your work allows us to point out that this is really inadequate work. And this is just these are all comments, Natalie. I don't expect you to say anything, but you know, it occurs to me that we in our work really work based on CDC, and CDC is a federal government agency we're all familiar with to some extent. FDA is also a federal agency, and I think we confuse the two as working at that same level. I mean, they announce that they're working together, which is fine, but we're not dealing with the CDC with the FDA. They're very market driven and they're very industry driven. Mm-hmm. So, yeah, I don't expect you to respond to that, but I do appreciate your candor on this subject.
Well, yeah, and that's a good point, Neil, that like, and it's something I've talked about a lot. Like, I think the decision to put the Center for Tobacco Products at the FDA was just not a great decision, ultimately, because I think what's happened is that a lot of people that work at the Center for Tobacco Products came from the drug side. And at the drug side, you actually do end up, and I'm, for better or for worse, I'm not sure that I'm like applauding this, but that on the drug side, you see FDA working more closely with industry, because like essentially it's the same goal, that you would put out a drug that prevents or treats disease and that it would be safe and effective and not like cause additional harm. And I can kind of see that. But then when those people come over and start working on tobacco and don't appreciate the, you know, depravity of morality of the tobacco industry, and they start trying to work with the industry in the same way they would work with like the drug industry, you see what's happened. It's not like public health focused. And the CDC is public health driven and public health focused. And that's really, truly the difference.
Well, and then if you're a drug manufacturer, you don't get to just throw drugs on the market without that regulation.
Yeah.
So it's almost like they choose to treat tobacco products differently with their, so it is, I'll just still blame them. So.
Yeah, no, for sure. And it makes the work that you do, and I think that's what you're saying too, it makes the work that you do so much more important because the FDA leaves so many gaps to fill that, like, if you really want to protect youth, you have to be doing state and local work.
And that allowance and non-regulation of these products really helps us, or not really hurts us when we go into our legislature, because they are saying to us, well, if they're bad, why is the FDA allowing them? So, I mean, public health messaging doesn't matter if all they can do is point to the FDA. And I realize we're having a conversation about this here, but we did get another question. Give me one moment to publish this. If a product is denied and still finds its way onto the store shelves, who is responsible for enforcement and who gets in trouble? That is a good question.
So the FDA is in responsible for the enforcement, and who gets in trouble is an interesting question. So, you know what? I'm not exactly 100% sure who would get in trouble in that circumstance. I'm not even sure if the FDA is sure who they would assess a fine against in those circumstances, because I think the FDA mostly hopes that if they send a warning letter, it will all work out and that we won't have to worry about it anymore. But it's probably going to be the retailer ultimately that gets the penalty because they are responsible for only selling legal products. So I would assume that it's the retailer, but I can see how difficult it is for the retailer to even figure out what should and shouldn't be on their shelves because the FDA is mucking it up so much.
Well, and we can be honest and say the FDA would probably start their nasty letter protocol, which, like you mentioned, will start people to quake in fear. So, hopefully that would do it. So Natalie, don't see any other questions coming in. I want to thank you so much. I love your candor in this subject, and thank you for dealing with the technology, and thank you for everything. I appreciate you.
Yes, thanks to Clint for doing my slides for me. Sorry that was so complicated, but thanks for hanging in there with me too.
It's the end result we're looking for, so I appreciate that. Thanks again, Natalie.
Thanks.